Good morning.
Good morning.
Sarah Mansfield for the appellants, and I would like to reserve 2 minutes for rebuttal.
2?
Yes.
Okay, you may proceed.
Thank you. May it please the court. Today we are asking that this court reverse the lower court's decision to deny the decedent's 2018 will to probate and remand the case back to lower court for 2 reasons. First being that the lower court erred in ruling that decedent did not sign any part of her 2018 will, and therefore ruling that that will was invalid. Second being that the court erred in ruling that even if the will was valid, markings on the will made the entire will defective. I will address both parts, first focusing on why the 2018 will was properly executed due to decedent's signature on the 11th page. Tennessee Code Annotated 321-104A governs what is required for a will to be validly executed, stating specifically that there must be the signature of a testator along with 2 witness signatures present on a will. Now, the law is unclear exactly where on a will a testator's signature must be placed in order for it to be valid. This is reflected by the court's ruling in Ray Chastain, where in that case, the court stated that the law is silent whether a testator must sign in a particular location on a will for it to be valid. However, what is clear by that court and other rulings by Tennessee courts is that a testator must sign the will itself and not a wholly separate document. Now, the lower court in this case ruled that the signature of decedent on the 11th page of the will was, which is headmarked affidavit, was a signature on a wholly separate document, not the will, citing to Chastain. However, under the legal standard laid out by Chastain Court, we're arguing that this is a signature on the will itself. Specifically,
even though it doesn't say will, the document that was signed says affidavit.
Yes, so the 11th page is headmarked affidavit. But however, the language that is used within both the affidavit and what is being considered the separate will clearly unite the two, I guess, documents, or draws the 11th page in. Also, to consider, the court in Morris did pay attention when the word affidavit is used by an attorney who is drafting the will. Obviously, the word affidavit is going to be given great, weight because the attorney is knowing this is a self-proving affidavit. In this case, there's been no testimony or no showing on the record of the will that an attorney drafted the will. There's some clerical mistakes within the will too. So again.
But don't we know from the decedent's 2017 will that the decedent knows where to sign her will? Because in 2017, she actually signed the will, not some separate document called an affidavit.
Yes. So in the 2018 will, while there is a spot on that 9th page where it says for her to sign, the statement where she signs on page 11, the language that is used within that statement above where her signature is states, I sign my name to this instrument, going on to say, I sign this instrument as my will. So I think it can be argued that she is signing under that statement, understanding that this is a part of the will. Her signature along with 2 witness signatures are below that. Again, language being used saying this is a will. On the 10th page of the will, witnesses again sign, and there's a statement above that stating specifically that the will consists of 11 pages. That is clear and unambiguous that the language used says the will is indeed 11 pages and decedent's signature is on the 11th page. And going back to Chastain, that court looked at 3 different things in determining whether or not signatures were on the will or a separate document. They looked at the plain language of the will, the plain language of the affidavit, and the statute governing self-proving affidavits, which is Tennessee Code Annotated 321-104.
If it was intended that by signing the affidavit, that was an effective execution of the will under the statute, why have the signature block on the 10th page?
And this is the issue here, is it's unclear as far as who drafted the will. It's unclear as far as the intent of, if that indeed was her intent to not sign the will. However, again, pointing back to the language, pointing back to the rulings in Chastain and Morris and how they evaluated whether or not signatures were a part of the will or in a separate document, they look, again, at the language of the will, at the language of the head-marked affidavit. And in this case, again, it's very clear that the will consists of 11 pages. That's on page 10, signed by witnesses. And also, decedent did sign a portion of the will, or portion stating that she signs her name to this instrument, that this instrument is her last will. It could be argued that's the understanding of decedent, that that was enough for her to sign the will and to make it valid, that her signing that statement is stating and giving the intent that this is my will, this is where I'm signing, and for me, this is being validly executed.
Well, I'm still troubled by the fact that a year earlier, she made a will, and she knew a year earlier what the statute requires for the effective execution of a will in 2017, just a year earlier. Mm-hmm. She signed the will, not the document style an affidavit. Mm-hmm. I mean, the fact that she didn't sign it, what would that suggest, actually? Since she knows how to properly execute a will, and we know that from what she did in 2017. Mm-hmm. I mean, what should we conclude by her not signing on the block that's designated on the will itself?
Mm-hmm. And again, I'll point to the part on page 11 where she is signing a statement stating that it is her will. Obviously, none of us were there. None of us knew exactly what she was thinking. If she, knew by not signing that portion that it was a part of the will, or excuse me, if by not signing that 9th page that it, invalidated that will or didn't effectively revoke her 2017 will. But going off of the facts that have been presented in previous cases that are similar to this, we're asking that it be evaluated of decedent signed a portion stating, I signed this will, I sign, even if it is on the 11th page, even though it is head marked affidavit, the language is clear stating, this is my will, this instrument I am signing now is my will. And looking again back to Chastain, there's a multitude of factors that court, along with Morris, evaluated in determining what language can be used within wills or within head-marked affidavits, in determining whether those are separate documents or wills themselves. Specifically, I know in Chastain, the court looked to see the words attach or referring to the will as the attached or foregoing document. In that case, the affidavit also had instructions stating attach this document to the will. In Morris, the court looked very specifically at the word on the affidavit referring to the will as a foregoing document. In this case, there's no instance of that being used. There's no instruction saying attach this to the will. There's no instruction or no mention of the will as a separate document, as the foregoing or as the above document. There's only language on that 11th page stating this instrument is my will, I am signing this as my will. And under that evaluation, we're asking that this court see that the will was 11 pages, states on page 10, will consist of 11 pages. That decedent's signature does appear on the 11th page with a statement referring to that page as a part of her will, and therefore as validly executed. With that being said, I will move on to the second issue presented, which is whether markings on the will make the will defective in its entirety. Tennessee Code Annotated 32.1-201 governs how a testator can revoke a will, stating specifically that a testator may revoke a will in part by physical act. And Tennessee courts look at testator's intent on determining whether there's been a valid revocation, specifically looking for concurrence of an intention to revoke coupled with an act of revocation. The court in Estate of Lewis stated that markings on a will don't necessarily validate the entire will or make the entire will revoked. In that case, they ruled that a testator can revoke specific portions of a will by physical acts, such as markings, while leaving the other portions intact. And that court went on to look at whether markings invalidated those specific portions. The court in Lewis ultimately held that there was not enough evidence on the record demonstrating the intent of the testator in that case to revoke the will in its entirety or even those specific portions of the will. I would compare this to In re Die's estate, where in that case there were markings made on specific bequests or names, coupled with the word void written next to those or in between the lines. In that case, the court did hold that there was enough showing of intent through the word void that was written next to the markings crossing out names or bequest to show that the testator in that case did intend to revoke those specific portions. Again, not the entirety of the will, but just those specific portions. In this case, on the will, there's just simple markings on the page through names. I believe on the third page there is an illegible scribble. No testimony was presented. There's nothing on the record about witness testimony that was indeed the decedent's handwriting. No witness testimony as far as the intent of decedent to revoke those specific bequests. There's no initials, no signature, no word void or anything next to those markings on the will to show the intent of decedent to revoke those specific bequests, similar to in Lewis.
So what should we do? Just disregard the markings altogether?
So not disregard the markings altogether. I mean, it's clear that there are markings. However, the lower court ruling that those markings revoke the entire will is not supported by the case law that's been cited. Whether those markings revoke those specific bequests is another issue. But I would argue that this is more similar to Lewis, where there's no coupling of intent, no showing on the record that it was the intent of the decedent to revoke these specific bequests. It's not similar to Die's, where there's the word void or something that is unequivocal showing that the decedent intended to revoke these specific portions.
So we should just disregard the markings altogether?
I would not disregard the markings. I think that, like I said, it's not supported by case law that there is intent. Tennessee courts have showed that intent is the key in determining whether or not a decedent or testator intended to revoke those specific portions.
All right, let's assume she didn't intend to revoke. What do you do with the markings?
I would ask that it be remanded and for it to be argued back there in lower court as to whether there was intent. Like I said, there's no witness testimony. Nothing was presented as far as if she made the markings, who made the markings, and so on.
Okay.
Thank you.
Good morning.
Good morning.
Peggy Mathis at the Nashville Bar on behalf of Marcus Washington, the administrator of the estate. I'm going to discuss the markings first because I actually agree with Ms. Mansfield that should the court not invalidate the will for lack of a signature, that it would be remanded for the testator's intent on why she did the markings and if she did the markings, because we have just not had an evidentiary hearing to determine what her intent was. Basically, the case is just like Chastain, in re estate of Thomas Grady Chastain. The testator did not sign the will. She signed the affidavit. I think the appellant is assuming that because of the language in the affidavit indicated that she wanted the affidavit to be part of the will, that it was her intent that that's her signature. But the Court of Appeals in Chastain found that, yes, it was the intent that she used the affidavit for her signature. However, the Supreme Court overturned that and said, no, you've got to sign the will. So there's also a little ambiguity here in that there are actually 12 pages submitted. So the will consisted of 10 pages. The affidavit consisted of 2 pages. On the 9th page of the will, that's entitled Article 9, Miscellaneous Provisions, and down at the bottom it said, "In witness whereof," I've submitted my signature, and a line for her signature. There is no signature. She did not sign the will. On the next page, the witnesses swear that, state that the above, that they witnessed the above signature, which was not there. She forgot to sign that part of the will. And it's basically blank, that the witnesses stated that she signed the above instrument in their sight and presence when she did not. And then immediately following, the affidavit contains her signature stating that she did want it to be part of her will and that she signed that instrument to be her will. I've never actually, except for this and Chastain, I've never actually seen a will with a witness, with a testator's affidavit on it. I think it would be ignored. You can't cross-examine her. There is nothing in the statute that allows for the testator to sign an affidavit as to the testimony. So I don't think that it's of any significance. The witnesses in the same affidavit swear that the testator signed the will. This document, as Your Honor pointed out, is entitled affidavit, not will. And in Chastain, the Supreme Court said it doesn't matter. The testator has to sign the will. Doesn't matter that she signed the affidavit. There were 2 separate documents. Chastain pointed that out, that the will and the affidavit are 2 separate documents. The affidavit is not necessary if the witnesses appear in court to testify, or in a matter of will contest when they have to appear and testify. So it's 2 separate documents. TCA 32-1-104 was amended to allow wills executed prior to 2016 to be given a little latitude on where the testator signs. But
Where the testator sign or the witnesses sign?
yes.
Which? Testator or witnesses?
I'm sorry, what?
You said that the amendment allowed some latitude for where the testator signed. I'm
Yes.
asking, is that true, or did it allow latitude for where the witnesses signed?
Well, I understood that it allowed latitude where the testator signed. It basically, yes, it did. It allowed, I thought it allowed where the testator signed. I might have misinterpreted.
Okay.
In Ray Lewis, the estate of Lewis, the witnesses didn't sign, they signed the affidavit, but not the will. And it's kind of the same thing. In Chastain, the testator did not sign the will, but signed the affidavit. But all of the executions of wills after 2016, I think the amendment only applied to 2016, and all of those after 2016 had to comply with the strict requirements of executing a will. Testator has to sign the will. 32-110 was amended, or I think it was probably 1972, I'm not positive about that. Adding the affidavit, because witnesses sometimes did not outlive the testator, and it became a problem that wills were invalid because the witnesses could not be found. But it still indicated it was a separate document that allows the witnesses to testify in that affidavit what they would testify to in court. Totally a separate document that was for the benefit of the court, actually. Chastain reiterated that both the statute and the affidavit established that the affidavit is a separate document from the will. The document, well, let me see. They amended, after the amendments of 32-1-104 and 32-2-110, the court did not relax the requirements to execute a will. In fact, they've consistently made them to comply strictly with the requirements of executing the will. This is a will, a form will, that apparently a lawyer did not draft, a lawyer did not help with the execution. No one knows, as Ms. Manfield said, no one knows who drafted the will. But because of the previous will, it was implied that it was a form will that she had used twice. Our position is that the testator must sign the will. In this case, she did not sign the will, and therefore the will is invalid and should not be admitted to probate. Questions?
Thank you.
Thank you.
I want to touch on something that Appellee's counsel stated. Again, this was a form will. It's unclear who drafted it. Going back to what Judge Armstrong, you have asked of the 2017 will versus the 2018 will and her signature. I think it can be said that decedent did not clearly know and did not understand what valid execution of a will looks like. She did not, there's no attorney who drafted it. There's no attorney's name who's on the 2018 will or on the 2017 will. It's unclear whether or not she really knew that by signing that 11th page and leaving the 9th page blank, that it could have led to where we are today. Going back to Chastain and that ruling, it's important to look at the standard that the Chastain court followed in evaluating whether that affidavit was a separate document or not. They didn't just look and say it's an affidavit, it's separate, done. They looked and clear language used within the will and the clear language used within that affidavit and determining whether or not it's a separate document. Again, the words above foregoing. In this case, counsel did point out the language used on that 10th page where witness signature was. It does not state that that decedent signed the above document. It states that they witnessed the document above, including pages containing witness signatures. That would include page 10. That would also include page 11, where decedent's signature is on. Again, page 11, where decedent has signed under the evaluation done by Chastain, does not have any of the language similar to that affidavit. It clearly unites itself with the will. It is clearly through that language and the language on page 10, a part of the will. Again, for that reason, we're going to ask that this court reverse the lower court's decision in validating the will.
What's your explanation for the witnesses having signed the will, but the decedent didn't?
Again, I wish I had a perfect explanation for you. I think I'm not gonna lie and say that this is a clear cut. It is a murky case. The will is not perfect. It brings me a lot of pain looking at it.
Okay.
But I think, again, I'm gonna point to the language that was used within the witness statements on page 10, along with the decedent's statement above where her signature was, and also the witness statement on page 11. It does, again, unite itself into the will with what they signed there.
Thank you.
Thank you.
Thank you.
Thank you, counsel, for your arguments and your brief. We will take this matter under advisement and attempt to render an opinion at the earliest possible time.